and gentlemen, welcome to another edition of Democracy and the Rule of Law, a show where we delve deep into the critical issues of law, politics, and governance. In today's episode, we'll be looking at two very important issues that have gained action during the week. First, we'll look at the issue of increment of rent. Of course, we all know, especially those who reside in Lagos, the issue of tenancy increment of tenancy rates has been an ongoing one. In fact, most of the cases in the magistrate courts that has filled the dockets of the court, of course, almost 50% of them will have to do with one issue of tenancy or the other. Of course, and primarily the issue of increment, of tenancy, quit notice, and all and sundry. So we're going to explore and also look into the laws governing the rules of tenancy, increment. When is the landlord supposed to increase, the rent? What is the status of the tenancy agreement between landlord and the tenant? What does the law say concerning increment of tenants? Can the landlord arbitrarily increase the tenancy rate, of his tenant without giving notice? So we're going to look at all of this in order to educate, the people on their rights, and their responsibility, when it comes to the issue of tenants, landlord, and tenants. And also be looking at the issue that also gained traction, the exclusion of HND graduates from the participating in the National Youth Corps. Of course, we are inundated, especially the students of the raised concern that their name was surprisingly removed from the list, in the portal of NYSC, and we were excluded, from participating in the mandatory 1-year NYSC service. So we are going to look at all of this and today's episode. Of course, we have our guests who are already seated in the studio this evening to help us look at all of this issue, and of course, tell us, what the law says concerning all of this and the way forward. So we'll go on a very short when we return. We'll introduce our guests who are already seated in the studio this evening. So we'll be back very shortly. If you are just joining us, you're on to your favorite program, Democracy and the Rule of Law, with me on the show this evening, Barrister Obiora Ume, a very respected legal practitioner in here in Lagos. We welcome you to the show this evening.
Thank you very much, and very good evening to our very admirable listeners.
And also with me, he's no less of a person, the legal juggernaut, Barrister Michael Mana. Barrister Michael, welcome you to the show this evening.
Thank you very much, Kenneth, and good evening, viewers.
Okay, without wasting much time, we'll jump into the nitty-gritty of today's episode. Of course, the rent issue is, of course, the elephant in the room. I'm sure our viewers and listeners are eager to get schooled on the issue of rent review and the landlord and tenant relationship. So, Barrister, you've had several decades of practice of law, especially in Nigeria, especially in Lagos State.
Yeah.
Of course, you've handled cases involving landlord and tenant relationship. Yeah. So I want you to at least help us to X-ray, give us an overview, of some of the common issues, in these areas that you have, and some of the gray areas where both the landlord and the tenant, most times they seem confused of their rights and responsibilities when it comes to this issue of landlord and tenant relationship.
All right, thank you very much. Now, issue of landlord and tenant relationship is an issue that has been there. And one common feature in it is that it's a contract. A contract is an agreement between two or more persons. And in terms of landlord-tenant relation is between usually two persons, the owner of the property called the landlord and the occupier called the tenant. Now, it is always assumed in law that parties to a contract usually have what we call an agreement, a meeting of the minds, consensus ad idem as to what form the basis of that contract. Of course, we know that, when there is a contract, there must be an offer, there must be acceptance, the condition, intent to create legal relations and all that. But you see, when we come to the issue of contract between the landlord and the tenant, there's always that edge that at least we have noticed between the landlord and the tenant in terms of the rent. Because the government has not done enough to provide accommodation for the masses. The available houses are not enough to meet with the demands of the teeming Nigerian populace. And that has made it now that the landlords dictate what is the rent. The landlord that has a 3-bedroom flat for letting would say, this is the amount I want to collect. And because there are a lot of people looking for accommodation, if he says his accommodation is 3 million, for example, or 1.5 million, or 500,000, whatever it is, depending on the location. If Mr. A does not want to take it, Mr. B will be eager to take it. Now, I remember that in years, the government looked at the situation and said, no, let us step into this and control the rent. Let it not be at the whims and caprices of the landowners. And the government came up with rent control and recovery of premises law, applicable in Lagos and other parts of the country. Each state has its own laws as regards recovery of premises and rent control. The determining factor there is rent control. Government trying to bring down the excessive charges made by landlords. It worked for a while, I didn't work. Presently, laws. There are 2 laws that govern landlord and tenancy relationship. The one that is applicable to Apapa land, Ikwe and GRA Keja, the rent control and premises law of Lagos State. Then the rest is governed by the tenancy law of Lagos 2015. The reason for that dichotomy, is yet unknown. But you see, in both laws, there is this parallel thing that is there. In the rent control, as well in the tenancy law of Lagos State, it has been clearly extrapolated that the landlords are to charge rents that are fair, just, and reasonable. That is it. In the other law, the same thing applies. And then is the landlord expected to increase rent 2 years after the tenant has commenced his tenancy relation with the landlord. But it's got that in some cases, a tenant has stayed for 1 year. The landlord may go ahead, and if the tenant is not ready to accept it, so go out of the house. I know a particular man, and that man is notorious that what he does is that he collects rent from the tenants, and at expiration, before expiration, we should quit notice, and he keeps on bringing rent every time, which is not what the law envisages. And then we also know that where a person is issued with increments of rent, the law says you must issue it at least within 6 months before the expiration of the tenancy in question.
All right, we'll come to that. Because of course, some people have argued that the 6 months does not apply to all kinds of tenancies, but we'll look at that. Some are 6 months tenancies, so obviously the landlord will not be give 6 months notice for 6 months, half a year.
For a monthly tenancy.
Yeah. I'm talking of what I said is not quick notice. I'm not talking of quick notice.
Oh, okay.
I'm talking of notice of increment of rent. Quick notice.
Oh, okay.
Yes. The law says that you must give 6 months notice of rent increment, and that will give the tenant your point to decide whether to stay, to negotiate and continue, or the alternative place. I'm not talking of termination of tenancy. No, that's not what I.
And I think you see the issue of increment of rent, as in Lagos here, governed by 2 separate laws, tenancy law of Lagos State.
Yes.
One that talks about the 6 months notice before you can give you can increase rents.
Yes.
Is in respect of the rent control and recovery of premises law.
Yes.
The tenancy law says reasonable time. Reasonable time, which can be determined by the landlord to be 1 month or 2 months. Reasonable time can be determined by the court to be 6 months or 3 months, depending on the type, nature of the tenancy that was created between them. For instance, if the landlord or the as my colleague has actually rightly said, tenancy law is a contractual relationship between, tenancy agreement is a contractual relationship between the tenant and the landlord. And so some of these terms are supposed to be put into writing and signed by the two parties. But very many times, the landlord will collect the agreement fee from the tenant and will never present any agreement. That agreement is what is supposed to bind the two of them. And some of these terms are supposed to be put down in the agreement. For instance, the fact that you are a yearly tenant does not mean that you are entitled automatically to 6 months quick notice. But if you have, that is what the law says, you are entitled to 6 months. But if you put down in your agreement and you decide to reduce it to 1 month, what you agree on is what the court would enforce.
Yeah, that brings us to the issue of this 6 months notice, the law,
Yes.
the conflict,
Yes.
between the agreement.
Yes.
The
The moment
you hammer on the fact that tenancy is a contractual agreement.
yes.
Okay, now it's a contractual agreement, and there is also a law, which the government has provided that governs this relationship. And sometimes there is usually this conflict, between the law that the government has made and the agreement that is being signed by the. For instance, you mentioned that the law has provided for 6 months notice at the expiration of your tenancy. So you are saying that agreement that have been entered between the landlord and the tenant takes precedent over what the law says.
It takes precedent over because the court will always enforce what is agreed by the parties. The court cannot write an agreement for the party. And so whatever you decide, you agree upon, is what the court would enforce concerning this contractual relationship. It is a different thing if you are talking outside the contract. You understand? And where you cannot go against a provision of the law. But once it is a contractual relationship, the court would not allow the law to override or to take precedent over what the parties have. Remember that the tenancy agreement is an agreement between landlord and tenant. The two of them sign. So it's not an issue of saying that the landlord will impose. If the tenant does not like that particular provision, he can tell the landlord, no, I cannot sign. How can you give me 3 months or 1 month or 2 months when the law says 6 months?
Yeah.
But
by some people have argued.
In some cases, the tenants may not even see the tenancy agreement before payment.
Yeah, but what are you
saying? Usually after the payment, that is now giving the copy of the tenancy agreement. Even some people don't even.
But he has a right not to sign.
Even though the law says that the landlord is under legal obligation to give tenancy agreement. And some landlords don't give. Even though they give, it's just like a formality or you sign. But the proper thing is the lawyer to the landlord and the lawyer to the tenant will look at the tenancy agreement.
Yeah, but I want us to clarify because the purpose of the viewers, these gray areas, this gray area. Some lawyers have argued that in the hierarchy of law, if you have an agreement that obviously contradicts the express provision of the law, that the law will take precedence over that particular
provision
Yes.
that seeks to override
Yes.
the law.
Mhm.
So, but you are saying that in this issue of tenancy agreement, if there's an express provision of the law already that you must give your tenant 6 months in order to enable him, obviously we will know the reason for this, to enable him to look for a suitable place, especially for tenants who obviously have family. And landlord having upper hand, in the agreement, because, elects to give 1 week notice. Are you saying that in the hierarchy of law, that agreement will not take precedence over the express provision of the 6 months? Because we need to really clarify this for the purpose of the viewers.
Yes, the thing is this. The agreement between the landlord and the tenants is not a law in the strict sense of it. Because just between the parties. Now, the law in this country, and of course the most other jurisdictions, is that the law is binding on everybody. And that you cannot enter into a contract that will violate patently the laws in force in the country. And in fact, there are so many decisions from the Supreme Court and Supreme Court that where an act is illegal, parties cannot, by compromise or agreement, make it legal. There's also a lot of authorities that if a court does not have power or jurisdiction to determine a case, the parties cannot, by agreement, connivance, or waiver, confer jurisdiction or powers on the court because the law is there. And this is what the law says. But when it comes to tenancy law, we see a different kettle of fish. What we see there is that the law says that where the tenancy agreement did not specifically state the period of is to be issued,
Exactly.
then it is 6 months that the law stipulates. Where it is not clearly stated in the tenancy agreement, 6 months will be applicable for a yearly tenant. And where the law, but where the parties have agreed and have taken a different period, maybe 6 months, maybe 3 months, or even a longer period, so long as it's still the consent and agreement of the parties, that the law will respect it. And the reason for that, the intention of the parties at the time they entered into that contract should be respected and enforced by the court. And that's where you see as if there's an apparent conflict between the regular laws, that the law is binding on everybody. And then this tenancy agreement and so on. The law allows the parties to enter into an agreement. And if they have said something that is different from the law has stated, then it will be allowed to stand for the parties.
Then, before we abandon that line of argument, what we have to realize is that if a landlord has collected money from the tenant for the purpose of giving agreement, that is what they always call legal and agency and all that. The legal is supposed to be for agreement. If the landlord has done that without giving the agreement, if the landlord eventually brings an agreement that is not in consonance with what the tenant wants to sign, the tenant can decide not to sign that agreement. Instead of signing an agreement under cohesion, and at the end of the day, he is bound by that agreement. So if the landlord, in his own wisdom, decided, or his own intrigue, decide not to give the tenant agreement before collecting money, and then brings an agreement that contains obnoxious clauses that the tenant does not want, does not like, and he says he doesn't want this, it should be this, and the landlord refuses, then refuse to sign the agreement, because we're back to the law. You rely on the law when the time comes, because the law says if there is no agreement. So the moment there is no agreement, you are entitled to 6 months
notice.
Yes, notice.
Okay. Yes, and another thing is that the ideal situation which the law envisages is that before you make payments, or what the law calls consideration, that the terms of the agreement are already known to both parties. Yes. which means that as a tenant, before you make your payment, you ought to have seen a copy of the proposed agreement, the tenancy agreement between you and the landlord. That is the ideal situation if it's said by the law, which means that at the moment you are making payments, you already know the terms, the conditions of the tenancy agreement and the covenant, the obligations under it of the landlord. For example, if the landlord's, if the tenancy agreement says that the tenant is under obligation to pay the land charges and the other charges that by law are made to be paid by the landowner, the property owner. If the tenant sees it and says, no, I wouldn't want to, agree to this, then, and that's before the execution of that agreement, then it is, in practice, in practical life, what you see is that tenant looking for accommodation sees an accommodation and he does inspection, is satisfied with it. Then the next thing is that the person, usually the agent or the caretaker, says, okay, if you make payment, then the agreement will be made available to you. And there's also another thing most people are not aware of. That is that the tenancy law imposes the obligation of issuing the tenancy agreement to the tenants without the tenant paying for it. It is the landlord's lawyer who prepares the tenancy agreements, give to the tenant's lawyer who verse it, and then it is the landlord who pays his legal practitioner for preparing the tenancy agreement. But of course, in Nigeria, and especially in Lagos, you see tenants being made to pay for tenancy agreement. And in fact, in one of the cases that were handled, we've raised that point. And even the court was surprised. Is that, and at the end of the day, we were able to show that that is what the law says. But most Nigerians don't know that it's not the tenant who is supposed to pay for the tenancy agreement.
Obviously, you're not supposed to pay for the legal services of another person.
Of another person.
Lawyer
You pay
is the
that
tenant.
of your lawyer.
Very well.
That's
the short of the law.
That's the law.
Okay, so let us move away from the disagreement now. So let's go to the issue of recovery of premises. Yeah, because you've said that landlord and tenant can agree that 1 week notice after the expiration of tenants. So after the 1 week, is it that okay? Can they also agree that once the 1 week lapses after the duration, they can move in to take over possession?
No,
But you just said that if they have agreed in their tenancy agreement, you said that the agreement there's a consensus added them in the agreement, and they are bound by whatever they have signed.
Yeah.
So if a landlord and a tenant have signed that after 1 week notice and I can move in, that is what they have agreed and they have signed. So irrespective of what the law says in the recovery, can that be enforced? Just like it is also enforced in the 6 months. You said that since they can say the 6 months can be approved by agreement of both parties.
What the law envisages is what period of notice of termination of tenancy is applicable. Now, if for any reason, in the unlikely event that both parties agree that 7 days will be the appropriate notice to be given, and then the landlord gives the 7 days in the event of him wanting the tenant to vacate the premises, it does not translate to that after 7 days the landlord will now move in and use people of himself to pack.
No, what I'm saying is that after agreeing that 7 days, they went further in other part of the agreement to agree that the landlord can move into possession and take and recover possession and vacate after that 7 days. And they signed, both of them signed. Yeah. Wouldn't the same rule that applies in the agreement of the 6 weeks also
let me come in there.
But I want to before you come in there.
Okay.
Once the notice is served, call it 7 days, call it 1 month, 3 months, 6 months, whatever. And at the end of the period stipulated in that notice, the tenant did not vacate. The landlord does not have the powers under the law to rescue possession by force. Even if the tenant had signed that agreement, the law still expects him to go ahead to see issue what the notice to tenant owners into apply to recover possession. That to say that the owner will be proceeding to court to recover possession. That will be served. If even after that the tenant still did not go, the landlord is still under obligation to proceed to court.
Yeah.
The law never allowed him, in spite of what document they may have signed by way of agreement. In fact, there was this where a landlord said, well, that the tenant had agreed to vacate after so time. He had not vacated. He went and removed the roof of the building as a way of
Trying to eject
to force the tenant to vacate. And unfortunately for him and for the tenant, the day he removed that roof was in June of that year, and rain descended and destroyed many of the properties of the tenant, who went to the court, and the court held that what the landlord did was attempting to recover possession through self-help. With the Supreme Court has condemned in several cases and awarded damages of 2 million then against the landlord.
Yeah, but
so
now,
yes,
sorry.
let me comment. You see, the reason that the court has to enforce these other steps is that the first step is termination of the tenancy.
Yeah.
Termination of the tenancy is where the law says where there is no agreement between the landlord and the tenant, then this period will apply. After that, where there is a termination, there are further provisions for the steps that the landlord must take.
Yeah.
It is not conditional on the agreement. It says that after that, the landlord is expected to serve the tenant with 7 days notice of intention to apply to court to recover premises.
Why would that? Why would that be so?
That is a provision of the law. The law says after the termination, once you have terminated the tenancy, you now have to serve him 7 days to tell him that you are going to court. It is after that, the expiration of these 7 days, that you now go to court. These ones are not conditional on the agreement between the parties. Yeah. That is why the law has to be enforced. For any landlord that takes the law into his hands to try to eject a tenant after just giving him the quick notice, you have to give him 7 days notice. You have to go to court. In fact, after even the 7 days notice of intention to recover premises, if you don't go to court, you will still be liable for damages for trying to eject the tenant illegally. So one is dependent on subject to the agreement, and this one is a statutory provision of the law, which cannot be amended.
Yes, going by the logic that you propounded first one, that landlord and tenant is an agreement between two people. One is selling a service, another person buying, and they're expected to have consensus added them. And of course, the law expects that these are consenting adults, 18. They must have read through the agreement and they have agreed that this is the law governing them. And they have agreed because so many of the viewers should be concerned. You see some of the houses which go for 6,000 per year, 50,000 per year. And of course, as a lawyer, you want an agreement that allows the landlord to move into possession immediately the tenants or the expiration of the tenancy agreement, and is not renewing. And you now expect, because the law provides that you need to go through the court, that a landlord who collects over 60,000 a year will now have to start going through all these onerous ways of going to court, employing the services of a lawyer, which obviously he is going to pay more than the 60,000 naira that he's collecting as rent. Don't you think that law in this instance is putting a clog, in the real estate sector? Because so many people are having issue investing in real estate sector, especially this issue of going to court, the time lag, and all of that. And most tenants are also exploiting, these provisions of the law.
You see, the tenancy law is expected to protect both the landlord and the tenant. It's not only one-sided, both tenant and landlord. Now, if the landlord is in his wisdom these days collecting 60,000 naira in a flat or whatever, which I don't know which side of the country that is applicable. and then
because I've seen a landlord has come to me for eviction and 60,000. I was not asking, how are you?
Maybe in a room somewhere.
Yeah, in a room.
At the end of the day, the landlord has given this tenant quick notice, and the tenant refuses to go. Persuasion is better, because if you go to court, and I doubt any lawyer that will collect that kind of money to eject a tenant. And in any case, if you must eject a tenant and bring in new tenant, because the main purpose of always ejecting one tenant and bringing in another is because this particular tenant is heavy, he doesn't want to pay the increment.
Exactly.
And you have discovered that the property you'll be giving to him for 6,000 is now going for about 120 or thereabout, and the person is insisting on paying 60. So you can put the money to and ensure, because if you take the laws into your hand, you will pay more than what you are supposed to have paid to go to court. I can't even say 100 times more than what you are supposed to pay and get the tenant ejected. But the landlord does not have the power to take the laws into his hands by trying to eject the tenant. You can use persuasion. You can ask the tenant, please, you see the things are that rosy, and I need this money. You can. The tenant can just move. I have seen several of them. Once they get the quick notice, they start looking for alternative accommodation.
Yeah, there are people
before you know it, they are out of the place.
Yes.
So many people don't like fighting these days because you know what.
Yeah, but we are also lawyers. We know that some people have stayed in properties for 3 years because of the issue of this law. They have remained in the property while the case is going on at the court.
Yes, the duty of the lawyer is to defend his client. So the moment a tenant comes to you, you want to see how you can drag it in so that the tenant. But another thing that I have to put in here is that the tenant is expected at the time of quitting the premises to pay the means profit, what we call means profit, and the arrears of rent if he has not paid. The means profit is from the time the tenancy was terminated. You now pay means profit to the landlord. So don't pride yourself with the mindset that once the matter is in court, I will not pay money.
We got a very short break, but a landlord who obviously spent 3 years in court might not have appetite to start going for means profit because even the tenant cannot still have money to pay for that. But we'll go on a very short break. However, we return, we'll round up on this topic and look at the second topic. Stay tuned, we'll be back shortly. Welcome back. If you are just joining us, you're on from Democracy and the Rule of Law. So we'll round up on this issue of tenant-landlord and tenant relationship.
Before we round up, I want to point out a few things. One, like my good brother said, some people have the wrong impression that once quick notice is served, they are no longer expected to pay rent. That is not the law. You are expected to pay your rent up to the day you vacate that premises, except the owner waives it.
Yes.
The next thing I want to point out is that, you see, sometimes determinant of price of commodities is based on demand and supply. Rents are skyrocketing because there are few houses that are available to many prospective tenants. And this draws us to the area that is fundamental. And what is that area? The issue of government involvement in provision of houses. Because the essence of governance in the first place is the welfare of the masses. And the law it shows that there must be shelter, accommodation. And in some other jurisdictions, other countries, government build houses or encourage private participation in the provision of houses, accommodation, and people take up accommodation, then they pay. And after a period of time, the house or the accommodation or the apartment becomes their
Yeah, they call
own.
it mortgage.
Yes. And of course, we have mortgage institutions in this country that they are expected to give loans to individuals who want to build houses and pay over a period of time, maybe 10 years, 20 years, and so on. But those things are not, realities in this country.
Yeah, but Lagos, I think Lagos State is doing that. This Lagos mass housing.
Yes.
They have one at Ogwa where they do this affordable.
No.
housing
Those
units.
words are just like drops in an ocean.
Yeah.
Because if you look at the population of Lagos and how many are those houses, and most of them there are few, if any, that is currently ongoing. Now, assuming government has taken it as a challenge to provide adequate accommodation for masses. Now there are categories. You have duplexes, you have 4-bedroom flat, 3-bedroom flat, mini flats, and so on, spread all over the place. And then once there are alternative accommodations, people will have choices. And if the government accommodation is there and the 3-bedroom flat is going for 700,000, and then the privately owned ones are going for 1.5, then the reason and logic dictates that you go for the one that is more pocket friendly. But the issue of accommodation has been abandoned by the government. It's creating the problems because as a tenant, you need a place, and they're telling you this is what you look if what are the other alternatives you have. You have limited. So it's an area that government must do something about as a matter of urgency. In fact, one commentator just saying that government ought to declare emergency in the area of operation, because as a human being, the basic needs you have, you must eat, you must clothing and shelter. And government seems to have abandoned that. These things are encapsulated in the Constitution, Chapter 2 of the principle of the policy of government. What government is out to do for the welfare of the masses, of course, is that the welfare of the mass is the supreme law. Now, government ought to encourage public-private, collaboration in the accommodation. If that is settled, then a lot of things will be fixed. And then finally, the government's efforts at regulating rent increment has not been very effective. I recall that during the era of Fashola as the governor of Lagos State, the government came up with a policy that ameliorate the sufferings of the masses, especially the tenants, and put in place some measures in the then tenancy law. And then in Lagos State, you go to get a place, they'll be asking you, are you looking for Fashola house, or are you ready to take the one that belongs to the landlord? The Fashola house is the one that they have made provision that somehow cushion the effects of accommodation. The tenant, the rent will not be much, and the period you have to make deposit. You understand? Before, by that time, it used to be 2 years and above. The law said no, you must not pay for more than 1 year. Initially, they were resistant, but as time went on, they adapted to the 1 year, but then the other thing that they increased the rent. So if government say you must not charge be above this amount, and the government does not make alternative provision, the tenants will be forced
to follow the back door.
Yes, to abide with whatever they are saying. So these are the few things we need to, that government need to do more in terms of provision of, yes,
in terms of housing. And there's something I need to chip in before we close on this. Some people have the misconception that the moment you are, your rent is still on, you have paid your rent, landlord is not supposed to terminate the tenancy. That is not. Now, if you are a yearly tenant,
yes,
and the landlord, your tenancy runs from January to December, and you don't have an agreement with the landlord that reduces the number of months that the landlord is supposed to notice to quit, the landlord is expected by law to give you 6 months notice to quit during the pendency of the tenancy. This is if the landlord wants to give you a valid quit notice, it will start from July to the end of December of the current tenancy that you are paid for. It is not after the expiration of the tenancy and you have not paid that the landlord is supposed to. He can decide to wait, but he can give you valid notice to quit during the period that your rent is still running.
Yes.
That is the position of the law.
That's correct.
Some people feel that the moment their rent is, I have had issues that tenants run to me and say, my rent is still running. Can you imagine I received this quit notice from the landlord? I read the notice and I advise him accordingly. Some too, because there are some jurisdictions that still anchor on the issue that the landlord must give the quit notice to expire at the eve of the expiration of the tenancy. So, but in Lagos, they said even after the expiration, the current tenancy law says even after the expiration you can give, or before the expiration. But there are so many other states or jurisdictions that still depend on that old provision that the tenancy must terminate on at the eve of the
anniversary of the
anniversary of the eve of the anniversary of the tenancy.
Yes.
Yes. That means if you want to give valid quit notice, somebody is a yearly tenant, 1st January to 31st December yearly. For you to give a valid quit notice in that case, because this notice to quit is a very technical issue, you have to wait until it is 1st of July. You can give the quit notice in June to start running from 1st of July to the end of December. That is when you give valid quit notice.
Yeah.
If it says you have there is that provision and you give a notice that does not expire at the anniversary of the eve of the expiration of the tenancy, that notice is invalid.
That's correct.
And that is where lawyers would drag cases for years.
Yes, like I said, if a 6 months notice is issued and it's got that it is a day less than 6 months,
yes,
it's invalid.
It's valid.
What the law expects is that there are another fresh notice ought to be given. Another important point to note is that where a tenant's rent expires, say, by March, and the landlord says he needs accommodation and wants to give a quit notice that will terminate by February, it is wrong.
Yes.
Because during the currency, dependency of that tenancy, you cannot terminate it by way of a quit notice. Yes, these are.
Okay. So, the issue of landlord and tenant, I'm sure that the viewers would have been very, very excited by some of this revelation that have come to light when it has to do with the issue of landlords and tenant relationship. Their rights, their liability, when it comes to all of this, for the issue of signing of agreement, which Barrister Bureau have said that it is the duty of even the landlord to pay for that agreement. Because oftentimes...
Let me drop a caveat here.
Okay.
There is a Supreme Court that says that if the the notice to quit is not valid, and the process of recovery has been put into use, the fact that you have received notice of the process of recovery and you are in court is enough to validate the quit notice.
Yes.
And that is what they are using in Lagos State these days.
Yes.
That if the quit notice is not valid, the moment you are given a process, they file a process in court and the process goes on and you are part of it, it means that it has validated the quit notice.
Well, we are aware of that judgment with Supreme Court. And that judgment is a clear departure from what we have known as the precedent. The previous judgment of Supreme Court is with the fact that once a quit notice is not valid, then because it's called statutory notice required that you cannot build something on nothing, that your notice is not proper, and as such, it cannot stand. That has been the decision of the Supreme Court over the years. But like my colleague said, there was this movement of the Supreme Court that came to, give them that says that every which notice is not valid, that the subsequent act of the summons and other things. Now, if you look at it logically, the law has always been, and has never been in that you cannot place something on nothing and expect it to remain. It will ultimately collapse. The statutory notice is invalid. Can a summons, which is to be based on the valid statutory notice, now validate what was obviously invalid? Then let's wait, because that's the final court. And we're expecting that maybe in future,
yes,
another judgment will correct that. Because like we saw in the area of fundamental rights, there was a time that a court of appeal judgment, came up to the fact that you cannot sue for your enforcement of fundamental rights when you cannot have joint application for enforcement of fundamental rights. That two persons or more cannot file one application. And that, created ripples. And some of us have created that, look, that if you have the same course of action, common interests and common grievance and so on, and the same thing, that you can go to court. Fortunately, another court of appeal came up with a different decision, and the Supreme Court has finalized that there will be joint application for enforcement of fundamental rights. Let's hope that in future the Supreme Court will have opportunity to read that judgment and come to what is at tune and in harmony with its previous decisions.
All right. This is where we'll draw the curtain on this. Of course, we are almost out of time. So we'll just give like two minutes to look at the issue of NYSC exclusion of HND holders. Of course, we issued before where there is even dichotomy in employment, and the federal government had to intervene with this HND and harmonize it. So, quite to our surprise, we're having the issue raised its ugly head, where some of this HND students, graduates has excluded from participation in NYSC. And we know what the law says, that for you to get employment in some certain parastatals, you need to have the NYSC certificate. What will be their lot tomorrow?
Well, the issue of national youth service, is not something that is optional. It's mandatory service to your country. And it's kept on grounds of age or other exclusions. Now, where the law has made it clear that whoever has graduated must go through the normal service to the nation, then is it proper for anybody or person or group of persons in government to exclude some students for no fault of theirs? The answer is no. Because you cannot make someone to suffer a deprivation, a denial for what he or she never did. The policy of government is that once you have graduated, you must do the compulsory 1-year service. And HND is now looked at as, close to, referable to a graduate in the secular university. And so, since they've been going to youth service over time, for some time now, what is the reason now for the exclusion?
Yes, I think I was even surprised when I heard that, because I remember that initially when this NYSC came up in 1973, NCE graduates were part of the NYSC. NCE, HND, and first degree holders. They were part of those who went for NYSC. At a point, they decided to exclude NCE and allowed only HND and BSc holders to participate. This one that they are trying to exclude, I don't know why they are trying to do that, exclude the HND and then only allow the graduates of universities to go to, is a very disturbing issue. Because if the dichotomy between BSc holders and HND holders had been resolved by the federal, why do you want to bring an unnecessary dichotomy and division again? I know as a matter of practice that very many institutions, very many employers, they don't really rate the degree and the first degree and HE as the same.
Yes.
In fact, some employers even prefer HND to first degree because HND is purely practical. You bring an HND graduate now into your employment, he knows how you are talking. He read mechanical engineering. He knows how to handle or repair vehicles and things like that. But a BSc engineering graduate might not be able to do what HND is doing because majority of their training is in the HND is in the practical aspect of it. But you see, in government institutions, I'm saying this because I know in the oil industries, in fact, they always look for these HND holders. You have your BSc, they will go there, they prefer to take a HND holder, apart from areas of professional areas like medicine and law that belong. All these other engineering aspects, they prefer HND holders to be. Now, in this era, the people are looking for ways to cope criminalities and all that. And you are sending out so many graduates of HND into the street saying that they should not enjoy that 1 year that is supposed to be a year to bring them into the position of knowing that we have left school. Let us collect peanuts to be able to face the future.
Yeah,
and you are now telling them that they should not. It is something that the government has to look into and resolve immediately.
And then the last thing I want to say on that is that instead of looking at the areas of excluding HND from youth service, government should look more into the areas of making our education more relevant to the realities of the time. Not just to certificate-based learning, but practical learning that will enhance the fortunes of the graduates at the end of the day.
All right, thank you very much for your insightful analysis and on this issue that we have raised, so that the viewers should be most delighted, for the enlightenment that have been brought to bear in these topics. This is where we draw the curtain on today's episode on democracy and the rule of law. Of course, catch us same time next week, and as we look into more and other insightful stories, for your enlightenment. And also do to follow us on all our social media channels.